She said, being spat upon at that point, she just kind of lost it. But again, I am by no means saying that that is an excuse, Your Honor, especially when you consider it was a child, and especially when you consider it was a special needs child.
Case of the people versus Diana Seaborn.
Good morning, Judge Simpson. Attorney Carl Jordan, P57226, appearing on behalf of Ms. Deanna Seaborn, and Ms. Seaborn is present, Your Honor.
All right, go ahead.
First of all, Your Honor, I apologize for running late. Right. I know that the time was changed, but I was in another court. No excuses, I apologize.
All right, very good.
Your Honor, with respect to Ms. Seaborn, she did plead no. I did go over the PSI with her. There are no additions, deletions, or corrections made. I would just like to address what I believe would be an appropriate sentence.
Yeah, go ahead.
They are asking, Your Honor, for 29 days, 365, and I believe that they're asking for that to be held in abeyance, but that you serve 29 days. I don't believe, Your Honor, that that would be appropriate. And I'm jumping straight to that aspect because, first of all, Ms. Seaborn is extremely remorseful for what happened. She did not give a statement because she was allowed to plead no contest due to civil liability. But make no mistake about it, she took her job seriously. She did not want to harm anyone, certainly not a special needs child. This is by no means an excuse, Your Honor. But when I asked her, why she may have done what she did, because she has no prior record, she said, being spat upon at that point, she just kind of lost it. But again, I am by no means saying that that is an excuse, Your Honor, especially when you consider it was a child, and especially when you consider it was a special needs child. But I do want the court to know that had that not occurred, she would not be before any criminal judge. And I do not believe that she will be in front of any criminal judge in the future. She will complete probation successfully and go on and live her life. There have been some consequences. She did lose her job that she had as a result of these charges. So now she is doing DoorDash in addition to taking care of her sister. But again, she's sorry, she's remorseful, and she wants the court to know she has learned her lesson. Thank you, Your Honor.
Anything you want to say before I impose sentence?
No.
Well, I'm going to say this, counsel, and I appreciate the elocution. However, when I look at the circumstances of this case, this is a special needs child. Certainly some things are going to occur. Certainly it could maybe raise one's ire, but to do these things is, in my estimation, inexcusable. I mean, these parents, through each stage of a process on a day-to-day basis, entrust their child to these folks. And quite frankly, when you violate that trust, it's inexcusable in a lot of ways, in my mind. I mean, in particular, that this is a child that really cannot defend themselves if they even comprehend exactly what's happening to them. I mean, which just has to be sort of the worst thing. Was there a victim's impact statement? I was expecting that there might be.
I did not receive one, and I do not see the victims present.
All right. It is a sentence of the court. Place you on probation for a period of 60 months. You're to pay $655 fines and court costs, $1,800 probation oversight fees. When can that be paid?
You said $1,800, Your Honor?
Yes, that's what I have. Yeah, it's 60 months.
Your Honor, she realistically says that she can pay $150 a month.
Okay. $150 a month. That will begin in January 2026.
Thank you, Your Honor.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. Will be subject to random testing as requested by probation. You are to complete the anger habits program. You're to complete 50 hours of community service. There's to be no contact with Elizabeth, Peter, or Eli Lorensky if I'm pronouncing that last name correctly, that is directly or indirectly. You are not to be working with and or around any minor children. There's to be no assaultive, threatening, or intimidating behavior by you. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to maintain employment with verification to probation. And let me just say this. Like I said, these parents entrust you. And, at no point, other than for the purposes of safety or other legitimate reasons, do you have the right to place your hands on that child? That's the only basis of you're trained, should have been trained, and I think you were, as to how to deal with these circumstances and these situations. You're having a bad day, losing control, and doing this kind of thing is never an option. And I understand counsel isn't saying it is an excuse, but it's not an option for you when you get into that role and in that circumstance. And so what I'm going to do is I'm going to order 365 days in jail. Give you credit for the 1 day that you serve. You will be remanded to serve an additional 29 days, and then the balance will be suspended. Defendant is remanded.
Your Honor, I spoke to my client about this, and she said, could she have time to get her affairs in order? And I said, well, really, what affairs do you need to get in order? I mean, the President of the United States could get his affairs in order probably quickly. And she said, I do have a daughter who's 14, and I wasn't expecting to have to serve any time because it wasn't part of the negotiations. May she have at least a few days so that she can arrange for a 14-year-old to go somewhere? She does have a sister, but her sister is the person that she takes care of. Her sister was shot. She's in the courtroom. So she truly does need to make provisions with respect to her daughter. And she understands if she...
At the moment this was happening with the child, was that child permitted to make any arrangements for their care? Probably not.
Of course not.
I will not pay her the same courtesy. Defendant's remanded. She'll go today.
Thank you, Your Honor.
Thank you.